Maybe start then with the case of Bruce Lee Harrell, State of Florida versus Bruce Lee Harrell.
Well, Judge Thompson, if I could have 5 minutes, please, for rebuttal.
Yes, sir.
May it please the court. My name is Jeffrey Casey. I represent the state of Florida in this matter.
Yeah, I want to direct your attention to the preservation issue.
Yes, sir.
They say that it wasn't preserved.
Yes, sir.
And you acknowledge that, just like a defendant, the state's got to preserve issues too, right?
We do, yes.
And 924.051 requires that the legal argument have been sufficiently precise that it apprised the trial judge of what your argument was, right?
Exactly. Yes, sir. That's correct.
All right. Now, your legal argument that you're trying to advance on appeal and maybe advance below is that the search was incident to a lawful arrest.
That is correct.
Search incident to arrest exception to the warrant requirement, right?
That is exactly correct, Judge.
All right. And the rationale for that exception to the warrant requirement is that when someone is arrested, the policeman can search the passenger compartment of the car incident to the arrest to find out if there's any fruits of the crime, instrumentalities of the crime, or weapons, right?
Among other things, yes.
Well, tell me, I don't think there's any other purpose.
I think that probably does cover it, all of, or other instrumentalities or evidence of
Instrumentalities, evidence, or something that might affect officer safety.
or of another crime, which occurred in this case.
Okay. Well, I don't want to belabor the point. I mean,
Sure.
These are the essential purposes, right?
Yes, sir. That's correct.
All right. Now, you acknowledge that the prosecutor did not argue to the lower court that he or she certainly didn't use the language that it was a search incident to arrest.
I don't believe the word search incident to arrest in that.
Phrase. Artful.
Well, I think, yes. I think artful would be some magic words. Mm-hmm. That is, something specific that we have all come to know that by a catchphrase might indicate that he's searching for instrumentalities of a crime or fruits of this offense or weapons. That's what the law allows. That's what the Supreme Court allowed for a bright-line rule for the search of the passenger compartment, search incident to arrest. Search incident to arrest would be the buzzwords. But I think...
But you could either argue, it seems to me, you could either argue like a lawyer and argue what the theory is, what the legal theory is. Judge, it was a search incident to arrest, or judge, it was a search to uncover the fruits of the crime or the instrumentalities of the crime or something like that. Or perhaps you could suggest to the court that what the purpose was for the search. But you know, beyond that, I don't see how you preserve the issue.
Well, and I think actually the prosecutor did. On page 64 of her argument, the part where she says, the officer testified based on his experiences, the defendant performed poorly on his exercise, that he missed his head, he missed his nose on the hand-to-nose touch. One example, he indicated that he was placed under arrest for DUI. After he was placed under arrest, the officer testified he searched his vehicle and found the container that contained the crack cocaine in the driver's seat.
Why did the officer articulate to the court during the suppression hearing the reasons he searched the vehicle?
He stated that he believed that it was an inventory search.
All right.
His characterization was an inventory search.
Well, fine. Would you agree with me that the state can have multiple reasons why a search was proper?
Certainly.
That is, I had a warrant, it also was in plain view, and it was abandoned. There would be a number of reasons, but that they could, as an alternative, present to the court. Is that fair?
Yes.
Doesn't the defense then say, well, as to this one, no, there was no valid warrant because as to this one, it was not in plain view. It was in a locked safe behind a picture and behind a wall. And as to this one, but doesn't that give the state the reasons why and the defense reasons why it is not a valid search?
The defense, I'm not exactly sure I understand.
You might be talking about the second case.
No, what I'm suggesting is, as an analogy, you have reasons why you can search a person or a car. You can multiply it, 1, 2, 3, 4, 5.
Certainly.
Did you do that in this case?
One of those was done to a much greater degree than the other.
Well, here's my problem. To what degree at all, from the officer or from the attorney below, was there an articulated reason why this search is valid?
And that I think is exactly it. This argument, small though it is,
Well, if it was so small, how could the defense then say, aha, but that's not right?
I think he was arrested and he was searched following the arrest. His car was searched following the arrest. Ought to be the tip-off to the
Okay.
defense.
Well, let's go to the judge. The judge said, I'm denying because. Did you then say, well, Judge, you missed this other point, the tip-off?
We did not.
Okay, so the judge could not correct his error at the time.
The state's position is the judge was presented with it during the course of the state's argument.
Well,
The state did not.
let's assume the judge didn't recognize you were presenting it. Did you say, Judge, you made an error, here's another theory that is obvious that was presented, and you could then hang your hat on that?
Those words were not spoken.
What words were to let the judge know he had error during the course of the suppression hearing?
After the court's ruling?
Yes.
None.
Well, isn't the purpose of an objection to let the judge know and that there's an error made and the judge can correct it?
I would say that, Judge Thompson, once the ruling, although I guess the trial court was free to change its ruling, once the ruling is made, it's incumbent on the lawyer to say, thank you, Judge.
Even if the judge made an error and the lawyer can show the judge made an error? Judge, you don't understand the law, let me give you a case to show that here's why we are right.
I think certainly the better practice would be for the lawyer to make a bigger case of, this is my position. I think there can be a justification on this ground and this ground and this ground, as you had said earlier in your example. They were not done to that degree in this case. We accept that.
Well, I think you were about to tell me what the lawyer said. At page 64, all I read in that is that the policeman had probable cause for the traffic stop, and the policeman had probable cause to arrest the defendant. Something else in there that...
The next, and yes, actually, Judge Thorpe, right after that, after he was placed under arrest, the officer testified that he searched his vehicle and found the container that contained the crack cocaine in the driver's seat. And that was exactly a search incident to arrest.
Is that a statement of what factually occurred, or is that a lawyer expressing to the court a legal theory or a legal argument?
It's the facts that justify the legal theory.
So if a prosecutor told the judge in developing a case factually that an item was located where the cop could see it, judge, that the marijuana was right there on the seat, that lawyer has made a plain view argument.
Yes, Judge Thorpe, he has made a plain view argument, although he didn't use the catchphrase, the buzzword, plain view.
Right.
He said he was lawfully where he was supposed to be, and he looked on the table and he saw the big bag of marijuana.
Yeah.
That would be a plain view argument.
Well, I think you added the lawfully where he was supposed to be in there, which is more like legal argument than just a statement of fact.
In this case, the justification leading up to it was he was properly stopped for a traffic infraction. The officer did all of the things he could do to determine that a person was under the influence of alcohol while driving, arrested that person properly, and then searched the car right after that.
But you do acknowledge that if we determine that the legal argument was not precise, that the state loses.
The next issue then would become whether this is fundamental error.
Well, when did you first raise that it might be fundamental error? You have 5 minutes remaining.
Here, not
In your brief initially or in your reply brief?
I believe it's in the reply brief.
So you can raise an argument for the first time for the defendant, appellant, to respond to in the reply brief?
I'll go back and check during my opponent's presentation.
That's convenient, where they won't get a chance to respond. That way you
But
have the last word.
I'll try to answer the court's question, but I don't remember off the top of my head.
I assume that it was in the reply brief, and that's the only place it was raised.
You can't do it, counsel. First time for reply brief.
I don't have an answer for that.
Mr. Casey, what does the word precise mean? And does it square with your definition of a description?
Without a dictionary definition of precise, I think precise is sufficient to put the trial court on notice of what your argument is. If you put the trial court on notice of what it is, it's sufficiently precise for purposes of 924-05.
Okay. And is there any case law that suggests that?
I haven't found any case that defines with specificity in this particular context what precise is.
Or with accuracy.
Thank you.
You've got 3.5 minutes remaining.
Good morning. May it please the court. Stuart Hyman on behalf of the appellee.
All right, now with this caveat, that you're already on an uphill situation with me. I want to ask you a couple of questions. All right. You acknowledge that if the correct legal argument had been made, New York State versus Belton search incident to arrest, that this falls squarely within the Belton exception to the exclusionary rule.
Your Honor, with all due respect, we would take issue with that because I think in this case what has been created is a legal fiction.
All right, well, forget about the argument. Forget about what the cop said about inventory just for a minute, okay?
Okay.
And let's just go with what happens. And let's say the cop's not a lawyer and he doesn't articulate a legal theory why he did it. It's a Belton scenario. It falls squarely within Belton. Do you acknowledge that?
With all due respect, and maybe I'm circumventing what you're asking, but I'm trying not to. The officer in this case never insinuated or even remotely indicated that he was concerned about looking for weapons or for contraband.
Does he have to do that? Let's say the cop just arrested the guy and went and searched the passenger compartment of his car. Is there any case law that says that he actually has to have an actual fear that there's weapons or fruits or instrumentalities or anything like that before he does it?
I think in the Belton case it talks about the purpose of a search incident to arrest and what the intent is behind it. In this particular case, the officer never expressed that kind of concern. And in fact, on my cross-examination of the officer, I used the word search, and he corrected me.
Okay. Let me ask you to distinguish the Valdez case, State v. Valdez. Tell me why that case is not directly on point here, but for the preservation issue.
Again, our position is that when the state asked the officer because I believe it's the nature of the search that controls.
Well, in Valdez, the officer said that he was doing an inventory.
But I think that I think that's a case where factually he was mistaken about what he was doing. That may be a case where it was a clear mistake. In this particular case, I don't believe the officer was mistaken. I believe this officer actually candidly expressed what he was doing there. He was concerned about values or things of value in the car.
Let me ask you a question. Have you ever heard of the tipsy coachman rule as used by appellate courts?
I think I've been the victim of the tipsy coachman.
Or enlightened, depending on your point of view. It says briefly that the lower judge might be right, but for the wrong reasons. You would agree that the officer had the right incident to an arrest to search the vehicle, correct?
If his intent was that he was concerned about getting contraband or weapons.
Okay. But he had the right to do it, correct?
Under the circumstances where he believed that that's what he was looking for.
Well, here's the flip side of that. Suppose everything happened exactly the way it did, and the officer said search incident to arrest, would that change the reasons why he searched or what he found?
I think if that was his true intent, then you wouldn't be dealing with illegal fiction. But when somebody has expressed under oath, and see, this is why I think this preservation of issue even came up.
Well, here's my question to you. Isn't this a tipsy coachman rule as applied to the law enforcement officer?
I don't believe in this case it is.
Why not?
I think that the trial court, I think everybody in that courtroom, including the police officer, the judge, the prosecutor, and myself, believed that this officer was conducting an inventory search. Every time it was brought up that he was...
Everybody there was wrong, but there was a basis for the officer to do the search.
But I think that basis has to be expressed in the record in some kind of testimony or something to support that theory.
Oh, wait, why does the officer's intent have anything to do with this? Isn't it the simple fact of the arrest and the availability of the car that's the critical subject? Not whether he had an intention to do an inventory search or an intention to do a search incident to arrest.
I think that kind of just general principle would be like a rubber stamp that any time anybody's arrested, a police officer can go search a car. All he's got to do is say the magic words, search incident to arrest.
As opposed to a gotcha where he says the wrong words even though he had the perfect right.
I'm not, in this case here, that's where I had a problem in this case with the state's argument, because I don't think this is a gotcha case. I think this is an officer who was candid on a witness stand when he was expressly asked, were you searching the vehicle? I want to correct you, counsel. I wasn't searching the vehicle. I was conducting an inventory search. And when the state initially in the direct examination asked him after you arrested Mr. Harrell, what did you do next? I looked through the car because I was concerned about values, things of value in the car.
Well, I guess what Judge Thompson was pointing to is that suppose he had a perfect right to do one but not the other, and expressed the wrong reason for his search. I mean, why in the greater scheme of things does that make any difference?
Well, because I think also you look back at the Florida Supreme Court case of Dobbin when it deals with stops of vehicles. And in that case there, I think the language of the Florida Supreme Court was you have to look at the asserted basis that the police officer gives for stopping the vehicle and see whether those objective facts constitute probable cause.
That's different, though. Here you concede, I think, that based on the noise violation, the officer could have stopped the vehicle.
I'm just analogizing that to an asserted basis.
Let me ask this question. What harm was it to you as a defense lawyer to hear an inventory search argument as opposed to a search incident argument at the time you were arguing to the trial judge?
Because I would argue to the trial court that there was no evidence in the record that this was a search incident to arrest looking for weapons or contraband or evidence, that the true intent of this officer that he expressed on the witness stand was to look for value, things of value, an inventory search. And, you know, I think what's happening here is form is coming over substance. The substance of what happened in that court was that this was an inventory search. He expressed it was. He operated under that pretense. The court operated. I think the prosecutor didn't make the argument of search incident to arrest because ethically she heard the police officer correct himself on the witness stand and say, I wasn't conducting a search, I was conducting an inventory. And I think ethically she was hard-pressed to argue to the court below that it was a search incident to arrest when her own witness was saying something different on the witness stand. And I think everybody in the courtroom was under the whole arguments and everything else all went towards inventory. Everything moved that way. And it was because the tone was set by the testimony of the officer that this is an inventory search. You can call it a search, but I'm not calling it a search. I'm calling it an inventory. If he was mistaken or was mischaracterizing what he was doing, he certainly had the opportunity on the witness stand at that point in time to say, counsel, you're right, I wasn't doing an inventory. I was doing a search incident to arrest. I was looking for contraband. But instead, he was saying, I'm looking for things of value, And that's what an inventory search is. I mean, the testimony falls squarely into what an inventory search is and what its purpose is.
Would your argument be that there are different criteria for the different searches, and you were defending against one and not the other, therefore you couldn't effectively represent your client?
That I would argue, because if we were dealing with search incident to arrest, then I would have been going under a different theory and probably under maybe even some different case law, such as some of the ones that were cited in here, that the nature of the search controls. But the court below wasn't given the opportunity to even address that issue because the state never properly argued it. If they wanted to argue it, I think they properly argued the theory that applied in this case, which was an inventory theory, which they didn't have the evidence to support. But I think if they'd have argued search incident to arrest, that would have been contrary to what was happening in that courtroom and what that officer had testified to. And I don't think it was a mischaracterization by the officer. I think the officer was being very candid in what his intent was.
So you don't accept my tipsy coachman rule as applied to the officer?
Judge, I accept whatever the court decides, but I believe that in this case the tipsy coachman theory would not be appropriate in this case, because I think that everybody in the courtroom below was going under the theory of inventory search. And if it was a mischaracterization, I thought the officer was making a mistake, I probably wouldn't be here, or I'd conceded or whatever. But I think that this officer in this particular case was being candid, and we would be distorting what happened below and what his intent was by calling it a search incident to arrest. Thank you.
Thank you, sir.
If I could respond to one thing regarding Belton. The quote that I put in my brief regarding Belton, but I think it's very important to hear. Custodial arrest of a suspect based on probable cause is a reasonable intrusion on the Fourth Amendment. That intrusion being lawful, the search incident to the arrest requires no additional justification. So I think once the arrest happens, the reason why he was searching or the thoughts behind it or the officer's motivation is just not relevant, according to Belton. It's a bright line rule.
Well, no, what counsel's arguing, and I read your cases like Valdez and Williams, and what he's arguing is that this officer had two options, presumably. He had the option to conduct a search incident to arrest. He might or might not have had the option to conduct an inventory, and he consciously knew. I think counsel's saying he consciously knew what those two options were, and he consciously made a decision. I mean, suppose you had an officer that said, oh, I knew that I had the right to search incident to arrest, and I thought that I had the right to inventory. But there is a distinction between the two, because in inventory you get to go in the trunk, and a search incident to arrest you can only do the passenger compartment.
Right.
So I decided that I didn't want to do a search incident to arrest. I made a conscious decision to conduct an inventory. In that scenario, is the state free to argue that, well, he could have done a search incident to arrest, therefore he did do a search incident to arrest, therefore the evidence comes in?
Well, I think the answer is in Colson from last year from this court. The officer's characterization of the search as an inventory search does not control it.
Well, but that may be there's a difference between a mischaracterization because out of ignorance. The officer didn't go to law school, and he just wanted to search the car. He didn't really exactly know which legal theory. He called it an inventory. There may be a difference between that, and you might be right, but there may be a difference between that and a conscious decision not to search incident to arrest, but to do an inventory instead. And if that officer is sophisticated enough to know the distinction and actually elects to do the latter rather than the former, then the state, in that situation, the state's out of luck, right?
I think if he had been in this case, then he would have known to talk about what the policies were and how he followed them and all that sort of thing. He called it an inventory, but he did actually nothing that's inconsistent with a search incident to arrest. Nothing actually that's really consistent with an inventory, because he didn't talk about what.
What troubles me is articulating that to the judge so the judge could make an informed decision. And you present a theory, or your colleague below, the judge worked on that theory, as did everybody in that courtroom, and then you changed it.
We acknowledge that it could have been done considerably
Well,
better.
but it's a matter of prejudice to the defendant, too. He's operating on a theory that trial counsel suggested there was one reason for the search. Defense counsel defends on that basis. He doesn't defend on the other basis because it's not raised. I mean, I can see a prejudice. I'm not so much concerned about whether the police officer understood what was happening as I am whether the legal arguments made below would have given the defendant an opportunity to defend against that.
I think in this case it would have been argued in argument as opposed to argued because all the facts were there to support a search incident to arrest.
Yeah,
Those were all developed.
Your colleague was supposed to articulate the right reason for the judge and for defense counsel so that defense counsel would have an opportunity to address it.
And certainly I wouldn't be here this morning, I think, had that been done to a greater degree.
Thank you.
Sure.
Your time has expired.
Interesting.